Hello and welcome to another edition of SNJ in Conversation. I'm Tania Tirraoro. We've been hearing a lot recently about home education, of course, because of the lockdown and how some parents are now considering it as a long-term option after finding their children have thrived while they've been learning at home. And other parents really do want their children to go back, but have found it's not quite as easy as it should be, especially when it comes to getting the SEND provision that their children need to be back into place and to stay in a safe environment in school. And for some, obviously, there is no option because they don't have a school place to go back to. So today we are talking about two subjects. One is the SEND provision that your children should be entitled to, whether they've got an EHCP or not, and also education other than at school, or EOTAS, or home education. And with me to expand on these is our columnist, Hayley, who is an SEN legal expert solicitor, and her colleague, Nicole, who specialises in education other than at school. Hello, ladies.
Hello.
Hi, thank you for joining me. Hayley, can we start with you? What is the basics of what rights parents have to, at the moment, whether their child with SEND has an EHCP or not?
So all children should now be back at school. So from the beginning of September, all children were expected to be going back into school full time. And I know some parents have been battling with schools about this because we've heard a lot of schools are employing risk assessments, which are actually preventing some children from attending. But that is actually unlawful. All children should now be back in school, and particularly children with EHC plans should also now be receiving everything that's set out in Section F of their EHC plan. So over the time of COVID, this was reduced down temporarily to a reasonable endeavours duty, but it is now back completely in force. So any children that have an EHC plan, anything in Section F should be being delivered as normal. Now the children are back in school, and all children should actually be back in the school setting as well. Any parents whose children are being prevented from going back should obviously take advice on that, because that's an unlawful position.
And what about if they don't have an EHCP and they've just got, say, an assessed plan due review? Presumably the law is the same for them as well.
Yeah, they should still be back in school full time. They shouldn't be prevented from going into school. They should be still receiving the support as set out. And obviously, if they require greater support than the school and can provide from their ordinary resources available to them, then they need to seek the possibility of getting an EHC needs assessment and getting a request in for that. But all children should be back receiving relevant support now.
But quite a few parents have been told that their children can't go back because, they haven't got the PPE, or they've changed the behaviour policies, and they're at risk of spitting. And the problem is, no parent wants to be unreasonable. It's a difficult time for everybody, and everybody understands this. So, they're less likely to feel that they can fight their corner. So if somebody says that to you, what do you do?
I mean, the law is in the favour of these parents, because while parents don't want to seem difficult, or it's a difficult position for the school, obviously, because they need to ensure everybody is safe, but also parents need to go on with their lives, and all children should be back. We are really facing a time where a lot of children are either going to be unlawfully excluded from school, or schools are going to be facing disability discrimination claims if disabled children are being prevented from going back for things like behaviour policies changing. The law is very much back in place to fully support these children going back into school. So if parents are getting risk assessments that say because of their children's behaviour they're not able to go back into school, or anything like that, it's completely unlawful. The law is back in force to enable all of these children to return. There are no temporary restrictions anymore. So if parents are being prevented, they shouldn't feel like they are being difficult. They're not being difficult. They're simply fulfilling their parental rights in order to enable their children to return to school. So parents certainly shouldn't feel bad about sending their children back to school. And that's what the government are certainly trying to encourage across England and Wales.
Nicole, what we've been hearing as well is that for some children during lockdown, many of their needs seem to have just vanished because their anxieties were better. And so parents have decided that maybe we should give home education a go. What are the special considerations in terms of children with disabilities?
I mean, what I would say is approach that with caution and be very clear about why it is that you're moving over to home education and the way that you bring that about, because the different ways that you do it will have different legal effects. So if you're in a position of actually, my child potentially doesn't need that much support in school, we're maybe looking at some differentiation or maybe some one-to-one support. And we found that within the home setting, we are meeting their needs really very well. We don't need any additional support coming in, and we're looking at elective home education. That might be something that works for you. But the reason I say approach with caution is that if you move over to elective home education, then actually the duty on the local authority to provide provision contained within Section F of the EOTAS plan can be eroded away, because under Section 42(5), what it says is that if the parent is making suitable arrangements for a child's education, that duty to provide provision is no longer upon the local authority. So basically, if you move over to purely elective home education, you may find yourself high and dry for the rest of the provision that's contained in Section F. If, on the other hand, being at home has either reduced a need that maybe wasn't there before, so anxiety in particular, school-based anxiety, school refusal, then it may be looking at now it's actually inappropriate for that provision to be made in the school environment. You physically can't get your child into school, or maybe you've realised that what was in place was so inappropriate before that now you've realised that it's inappropriate for that provision to be take place in school, in which case what you might be thinking of doing is moving over to education otherwise than at school. And the difference between elective home education and EOTAS is that the local authority maintain the obligation to make and fund the provision under EOTAS, which they don't under elective home education. So it's been really clear about why you want it and what format you're moving over to for home education, to make sure that you're aware exactly what both your obligations are and the obligations of the local authority.
So when you approach them, if your child has an EHCP, you have to make it very clear that you're not just going to go and do, home education, that this is education other than at school.
Absolutely. And it has to be on the basis that it's inappropriate for the provisions to be made in a more traditional education setting. That is the legal test, if you like, under the Children and Families Act. It's that education otherwise than at school can be made for children for whom it would be inappropriate to make that provision in an education setting. So it isn't just because that's what you prefer or what you think works a bit better. It has to be that it's inappropriate for that provision to be delivered in school.
So this is something that local authorities might be trying to muddy the waters with to avoid making any provision. Have you come across that?
Absolutely, yeah, all the time, and not even necessarily just at the local authority level. Sometimes schools as well. Just a suggestion: have you thought about elective home education? Because it really does absolve the local authority of responsibility. Your child would be removed from the role of the school. That would absolve them of any responsibility, and then you may find yourself in a position where, completely unwittingly, you have your child at home and the local authority has said, well, you're not entitled to any support from us anymore because you're electively home educating now, which once you're in that position, it can be quite difficult to find your way out of. It can be done, and particularly if you know what you're talking about in terms of the law, obviously it's far easier to do. But speaking to a lot of parents, I know they really do feel that they're trapped. They're in a situation where their child has come home, they're getting conflicting advice from different places, and they really don't know how to get themselves out of a situation that they never really intended to find themselves in the first place.
A parent actually asked this question. So what do I say? My teachers said, have you considered home education? For a start, that makes you feel really unwelcome.
Absolutely, absolutely. I mean, the way you answer that question really depends on where you're at in terms of your thoughts on home education. So what I would generally advise, actually, sort of a blanket starting point, is just stay well clear of elective home education, just because it really does put all of the onus for sourcing the suitable education on you as a parent. If you've not thought about it, ultimately, just say no. Your child's entitled to a school place. Your child is entitled to a mainstream school place if that is your choice, if that's your preference. And if home education is something that's not even on the radar, then just say no. They can't exclude your child, because that would leave them open to discrimination. So you really are very well placed to just push back and say absolutely not, that's not something I've considered. If home education is something that you've been thinking about, then I would say see if you can work with the school to start the foundation of a case for education otherwise than at school. And what you would really be saying to them, and what you would be hoping the school would support, is that we are now looking at education outside of a school environment because it's inappropriate for the education to be made in a school environment. So it's not just that this school isn't meeting need, it's actually that at this moment in time, no school would be able to meet needs, and to it would be inappropriate for that provision to be.
That might be in cases of severe anxiety and things as well.
Yeah, severe anxiety actually is one of the specific pieces of case law about education otherwise, that says that if a child does have significant anxiety, then that alone can mean that education otherwise is required. It's not the only reason by any means, but that is a specific example, and one that actually we were expecting to see a big increase in. See, a lot of children who might have had school-based anxiety anyway have had a very comfortable time at home. Parents are on furlough, they're at home with you, and actually that move now back into the education setting for a lot of kids is just a bridge too far. It's something they're not able to do at the moment.
So in that case, if the child doesn't have any HCP, they might actually find themselves applying for one. What we've been hearing from some parents, Hayley, is that children are being offered COVID plans. So not necessarily meeting needs, but what you can have at this time because of the current pandemic. And again, no parent wants to start arguing, saying, well, my child is entitled to this, that, and the other. When somebody says, you're in a pandemic, it's a difficult situation. How do you combat that?
I mean, the thought of COVID plans makes me want to cry a little bit inside, because they are just completely unlawful. And I think parents, particularly parents of children with STEM, really struggle with this kind of anxiety because they don't want to seem like they're asking for too much. I know there's a bit of a thing, with they're just pushy parents. It's certainly not the case. These children require support, and parents should never feel like they're asking too much, because all they're ever asking for is the right amount of support that their child needs in order to access education. And if your child needs a little bit more support than a child without any difficulties, then you should not feel that you're asking for too much by asking for any HD needs assessment in that scenario. So if parents are actually being told that they can have a COVID plan, it's essentially not going to have any base in law. And I would ask parents to stay well away from them, because if your child has difficulties, they're going to require support, likely going to require support throughout all of their education. So if you find yourself with one of these COVID plans, which actually require the local authority to do nothing, then you're just going to be fighting a battle, because you're going to be expecting support to come as part of this plan, and actually nothing is going to become as part of this plan. It's probably a good time to now say about timescales as well, because obviously because of coronavirus, we did have some temporary restrictions to timeframes. So for parents that were perhaps thinking that they needed to apply for an EHC plan, and the first instance of that is applying for an EHC needs assessment, then there were timeframes, modifications to timeframes put in place to essentially say that the normal timescales under the regulations don't apply anymore, and we're going to basically follow timeframes as soon as reasonably practicable. But by the time certainly this goes out to the viewers, they are no longer in force. They actually expire on the 25th of September. So what that should be telling parents is actually the law, again, is in their favour, because the government is saying that in actual fact, despite COVID and everything that's going on, we are in a position where local authorities can follow the legal timeframes that are set out in the regulations of 2014. And so what that means is, obviously, if you're applying, for example, for an EHCD assessment request, the local authority has that 6 weeks and now have to provide a decision on that 6 week mark. And we're very much back to the normal regulations that were in force before COVID happened. So I would encourage parents to not settle for anything less if they have even an inkling that their child needs more support. And they've tried, because parents would have tried with the school. You know, they're very active parents in this community. They would have sat down with the school teachers. They would have talked about some informal kind of send support. What more can the school do? The school are probably doing everything that they can. Lots of parents have, you know, tutors going into the home environment. They're sitting with their children. They're doing as much as they can. But we're really asking parents to be, you know, carers, teachers, you know, everything all in one go. And it's unsustainable for a parent to do everything. So if the children need support, don't accept, you know, COVID or temporary plans that have no legal enforceability. It's about actually just having the courage to say, this is what my child's entitled to, and this is what I'm applying for. And if you get mixed advice about you can't have that or you can't have this, just check your source about where that's coming from. And obviously there's lots of advice on your website about what parents are entitled to, Tanya, that parents can access. Obviously I put up there as well to tell parents exactly what their legal rights are. So even if parents can't afford legal representation, there's lots of free resources on the website that tell them about applying for an EHC assessment, what a good EHC plan looks like, that they can obviously access to know exactly what they're entitled to. But certainly don't settle for any kind of second COVID type plan, because they have no legal enforceability. And what you don't want is these children actually not getting the support they desperately need in order to obviously succeed in their education.
Nicole, for parents who already have EOTAS, somebody's asked the question that they haven't been able to spend some of their budget because they couldn't get the provision, and now the local authority is asking for that money back instead of allowing it to be used for, you know, catch-up tutoring and so on. What do they say to that?
Okay, I mean, legally this one's a little bit difficult to answer. Actually, the answer is actually quite clear-cut, but it's not the answer I think people would expect. So under the personal budget regulations, there is actually a specific regulation that deals with this. And what that regulation does say is that the local authorities do have every legal right to request that money be paid back to them in respect of provision that hasn't been sourced. So if there is a sort of a surplus of that budget, they do have the right to ask for that back. But of course, when those regulations were drafted, I don't think anybody was anticipating COVID was going to arrive, and that there would be a very legitimate reason beyond anybody's control as to why exactly those personal budgets can be used actually to get the provision put into place. So there's nothing in the law specifically about that. There's no hard and fast answer I can give you. What I would say is that under that regulation, the parent does have the power to ask the local authority to reconsider. And when making a decision as to whether or not to reconsider, the local authority does have to take into account all of the information that's been provided to it. So what I would say is, if you are in a position where you think, great, restrictions have been lifted, you know, these people can start coming back into the home, or whatever that provision is, we can start getting it put back in place. Get as much evidence as you can from that provider about why the catch-up is required, you know, reinforcing why that budget wasn't used. You know, we were in a lockdown, we couldn't come into your home. The only way that we can provide provision is face-to-face, or whatever your circumstances are. And ask the local authority to reconsider their position with the added, hopefully, the added benefit of evidence from that provider as to why the catch-up provision would be really useful, and you know why it's required, why it would help that young person progress towards their outcomes in their EHCP, and ask the LA to reconsider. Now, you can only ask the LA to reconsider once, which is really unhelpful, because of course they may well come back and say, well, we've reconsidered and we haven't really changed our minds. We've looked at the evidence and we still want you to pay it back. that leaves parents in a really, really difficult position, because actually under the regulations, if the parent doesn't pay back that surplus budget, the local authority can actually bring a claim against you for it. So they do have every right to pursue through the county court for return of those funds if it is financially viable for them to do so, which it might not be depending on the sums of money we're looking at here. And also we have to bear in mind that the personal budget regulations, it can be a little bit of a hurdle for parents to get one. You know, if they are in school, you need the school's permission, and the local authority definitely seems to have this ultimate veto of if they don't really think it's working, they can renege on that budget. And they could well review the budget arrangement and use the fact that there has been a surplus of budget which the parents have refused to return as a reason to say, well, actually, this personal budget won't be in place anymore. Now, that doesn't get rid of the local authority's obligation to ensure the provision is in place. So if it is in section F of an EHCP and the local authority do say, well, we're not going to let you have a personal budget anymore, they just have to step in and start paying for that provision directly. So that provision wouldn't go away, but what it would take away for a parent is that element of flexibility. You know, the reason that most people opt for a personal budget in the first place is that they want to have the control over who is coming into my home, when are they coming into my home, and making those arrangements for themselves. And, you know, we all have some degree of contact with local authorities. Their ability to do things properly or at all is very variable, normally on the side of not getting things done. So I would say you really need to weigh up what it means to sort of keep this budget and to spend it. Is it worth the potential pitfalls that could come with not returning that money?
What is the minimum home education or EOTAS and EHCP should contain? Because, for example, in a regular EHCP, you've got maybe hours or speech and language or whatever. Can it have things like PE or arts, or I mean, what would an example of a plan that you can describe as the minimum?
I mean, again, that's a very difficult one to answer, because when you're looking at home education, be it elective or EOTAS, you know, the requirement is there for it to be full-time education and for it to be suitable education, but there is no exact definition of what that should look like. It's going to vary from child to child. What is suitable education for one won't be suitable education for another. And when you're looking at EOTAS specifically, EOTAS can only exist in the context of an EHC plan, and it is where Section F of the EHC plan essentially steps in and becomes Section I. So where a child isn't attending a placement and you don't have anywhere named in Section I, Section F contains all of the information, all of the specification about exactly what that child should be receiving by way of an education. So the sky is really the limit. It all depends about what you can get put into your EHCP, what provision you can get written into Section F. If it's in there, it should be provided. So if that's specific provisions for art, you know, some local authorities don't like it, but you do get some that are quite willing to write various therapy, you know, Lego therapy, art therapy, talking therapies and things. They can all go in and be provided for under EOTAS. But it is very tailored to each individual child, you know. You should be, of course, most children will be working towards some sort of functional skills for English and mathematics, but that's not right for all children. For some children, you know, they're never going to be able to obtain functional English and math skills, and actually for them, their EOTAS package would be a lot more life skills based, a lot more practical skills based. So there isn't a set format that I could give you for EOTAS, because it really is going to depend on your child, what they need, and what that provision should look like within the home.
So, in fact, during lockdown, you imagine people who were already home educating probably had some kind of advantage because they had those provisions in place already. Now we're looking at perhaps other children being sent home because somebody's tested positive, so the whole bubble or the whole school gets sent home. And at the moment, I don't know how many schools have got efficient blended learning packages in place. If you have an EHCP, Hayley, what can you expect to be happening if your child is suddenly no longer able to go to school because of a local lockdown?
If your child has an EHC plan, again, it's back to this thing of Section 42 of the Children and Families Act being enforced. So even if your child is sent home, provision should still be being delivered. It's a must duty on the local authority. And again, it's back to COVID times a little bit, where ensuring flexibility. So if your child is not physically in the classroom because they're not able to be because of restrictions, then what support is being provided to them remotely? So if, for example, like speech and language therapy is quite a good one. In the pandemic, many speech and language therapists adapted, delivering therapy via Zoom or Skype or something similar. Then if your child's going to be at home for a week, then all of the speech and language therapy in their plan for that week, can that be being delivered via electronic means, however that works best for you and your child? And it's really about working with the parents, because parents aren't difficult. Parents just want support in order for their child to obviously be able to access the relevant support. So things that can be delivered at home during those times certainly should be. And there seems to be this culture that we certainly saw at the start of the pandemic of, oh, your child's at home, we can't do anything. And that's not the case. The law is very much, the onus is on the local authority. This must be delivered, and that is back and forth. So parents, if they are being sent home, need to be asking the school, well, how is this going to be delivered? Many schools have adapted to obviously some form of online learning. They seem to be using different platforms, but if that bubble particularly is being sent home, then is there somebody that can come onto the Zoom session? If they're, for example, if they have one-to-one support in the classroom, is that one-to-one able to come onto the Zoom session at the same time with the child and work through, requiring prompting and further explanation of what they're supposed to be doing? Is the one-to-one able to go into the home with relevant PPE? Similarly with therapists, if you've got an occupational therapist, are they able to go into the home with the relevant PPE? It's really about being flexible and working with the family. And I know it is really difficult because at every scenario, SEN parents feel like they have to just fight and fight and fight. But it needs to avoid being one of these situations. If you're sent home because you're a bubble and obviously you're waiting for test results, etc., as soon as it's possible for that child to go back into school, we need to be encouraging these children to return to the school, obviously, if they are ordinarily educated in the school. Because I just see a bit of a difficulty of, again, children being at home because of a bubble, and then local authorities and schools also then saying, well, actually, it's going to be difficult for us to get everybody back again. And we really need to have this focus on actually returning to school for those children that are able to do so, but for their packages to be fully delivered in accordance with their EHC plan. So it's about being flexible in the times of lockdowns, obviously getting back to the school environment as soon as possible.
And not the family being flexible. When you say being flexible, you're talking about the school being flexible.
The school, definitely. It's not a case of send them home and just get the parents to do everything. That's not what the law says. It's very much the school being flexible, the school working with the family, because parents are flexible. They will do everything that they can. It's more about what are the school going to do while this child, because ultimately the local authority is responsible for making sure the delivery of Section F in that EHC plan, regardless of where the child is. So we need to make sure that actually flexibility is employed and that the support is being delivered regardless.
Just to sort of add a little bit extra on to what Hayley was saying there, in terms of parents, don't be afraid to push to get the provision even when you're not back. Because I do with a lot of the social care sort of type work within the practice, and we've seen a lot more incidences because of lack of provision due to COVID, where families are now at a point where they feel that they can no longer provide a suitable accommodation for their child because they've just been left completely to their own devices. During the COVID lockdown, they had no support. These are children who've got significant difficulties, and it's actually resulting in family breakdown. Mm-hmm. Which is, it's really, really sad to be involved in those cases. It's really, really sad to see families come to that point. So what I would say is, please do push, because we want as few parents reaching that point as possible. It's very, very sad to get to that point, but it does happen when schools and when local authorities do just wash their hands of these children. So yeah, please do push for that provision.
And of course, the difference now is that, mid-pandemic, EHCPs did have their duties reduced, and now they are back in force. So schools shouldn't be allowed to say, well, you know what it was like then, it's the same now, because it's not the same, is it?
It's absolutely not the same. And like I said, the regulations and the Section 42 actually went back into force on the 1st of August. The last notice that we had was in July, so that's in relation to Section 42, which is the delivery of Section F. So since the 1st of August, this has been a must duty. So I would have expected schools to be telling parents exactly what support's going to be in place for their children as they return to school. If parents who are watching this or listening to this, their children still haven't gone back for whatever reason, certainly call the school, ask for a meeting, ask to understand exactly how this provision is going to be delivered that's in Section F, because ultimately, if it's not being delivered and you're not making headway with the school, then the local authority are under a legal obligation to deliver this in Section F. And if that is not being done, then certainly a pre-action letter can be written to basically remind the local authority, you are now acting unlawfully. This is quite clearly set out in this child's EHC plan. We've tried to put it in force, the school aren't cooperating, and in actual fact, you're now acting unlawfully, and that will force something to happen. It will force the provision to go back in force. And as Nicole was saying, it's very much about empowering parents, because parents just take on all of the burden and the responsibility. But it's nobody's fault that these children require extra support, and parents should feel empowered to be able to ask for the support that their child needs without being able to be felt like they are being difficult parents, because that's certainly not the case. And like Nicole's saying, family breakdown is on an up and up because and also decline in mental health. We're seeing parents' mental health affected because they're just trying to deal with completely unmanageable circumstances at home. The law's put it back in force since the beginning of August to allow this provision to be delivered, and there's no excuse for it. It should be being delivered. So if it's not being delivered, definitely push. And if you're not getting any recourse, turn to a pre-action letter to force the provision back in force.
And with that, we're just going to take a break. And for episode 2, for part 2 of this episode, we'll be coming back with more of your questions about EOTAS, home education, and how to make sure that your provision is back in place. So join us then.